Yes, I guess I'll go ahead and call the meeting to order. I'm sorry I don't have an agenda in front of me. I think, but that was basically all I needed to do, right? Let's call the meeting to order and then turn it over to you. So welcome,
Yep.
everybody. Stephanie tells me everybody's on the line. I'm guessing that they can hear me and we're good to go.
Yes.
So,
Okay, so after the call to order, the second thing is any agenda revisions or additions that anybody would like on here? Okay. And then there is no public hearing tonight. So for item number 3, there is none. And so we'll move on to number 4, which is other old business and new business. With it being our first meeting of the year, the first thing I have on there is introductions and election of officers. I guess I should have saved our introductions until after we started recording, but Stephanie Case, Planning Director for Gillum County, Principal Planner for Boardman.
Marley, I'm planner 1 here for the city of Boardman.
okay, and I'm Marta Michaelo.
We'll go ahead and hand it to you, Erin. I saw you on mute.
Oh, good. Erin Heidemann. I think I've been a member. This is my 2nd year on the council. So Blown Away Ranch, my husband and I farm in both Gillum and Morrow counties.
Perfect. Lori?
So I'm Lori Anderson, and this is my first meeting on the Planning Commission. Just been accepted to the position, so a newbie, but my husband and I farm in Gillum County.
Awesome. And then Gib.
Gib Wilkins. I've been on here 3 or 4 years. I worked as the public works superintendent for the city of Condon.
Awesome.
That's a great background, Gib.
And with it being the first meeting of the year, we do have the election of officers. Marta, how do you normally do that? Do you guys just open the floor and?
Yes, that's what we've done in the past.
Okay.
We've opened the floor, and historically we've just kind of turned it over. It's like, okay, are you willing to do it again? If you are, that's great. Let's do it again. That sort of thing. So, and so do I have anybody that would like to be the president? I think it's as simple as that. I mean, it's the chair. Is it the chairperson? The chair? Yeah.
The chair.
I move that we retain Marta as our current chairman.
I second.
Okay, we have a motion on the floor by Erin and a second by Gib to retain myself, Marta, as the current chairperson. And what are our other positions before we vote on this? Because maybe we could vote on it all at the same time.
I would say that the other position would be a vice chair or somebody, I don't know what the official title is of it. Most times you call it vice chair. That would fill in your absence, Marta.
Right. So I guess that I would nominate Gib because he is the second longest running member of the Planning Commission to be the vice chair.
If you would like me to, I can revise my amendment.
That would be great. That would be wonderful.
So if we just need those 2 positions, I move to amend my main motion by striking just Marta and inserting Gib as vice.
Okay, so we have a new motion on the floor that Marta remain as, am I still there?
Yes.
Okay, my screen went black. To retain Marta as chairman and Gib Wilkins will be the vice chair. So all in favor?
Aye.
All right.
Okay, motion passed.
Excellent. As a reminder, the next thing we have is planning commissioner recruitment. We do have 1 open position. So at the end of 2024, when we advertised, we had 2. We had 1 vacancy that was already existing, and then we had 1 vacancy that the term ended at the end of 24. With that, we had 1 person, and welcome Lori. And that left us with 1 vacancy. So if you guys know anybody, have them reach out to me. Probably in the next month or so, I'm going to re-advertise and see if we can move forward and get that filled. So
Great, perfect. And I think that was what we had on our agenda. So at this point, are you ready for us to move right into our training? Or and
Yes.
one thing, Stephanie, I would like to, if we could take a couple minutes and if you would just tell us maybe what's happening right now in Gillum County with the planning commission and what you've been doing from the planning department point of view, that would be really terrific.
Right, and I'll back it up a little bit so that way Lori knows too, because you guys heard from me a little bit in October, kind of where things were, so we'll back it up in July. The city of Boardman and Gillum County entered into a contract for department services to fill the role of the planning director. So under Oregon statute, a planning director is required for counties. And with that, the city hired me to fill that role. So I'm dual role. I'm the principal planner for the city of Boardman, and then I'm the planning director for Gillum County. So initially when we started, the IGA outlined several things to accomplish within this first year. And one of the things that was identified, not necessarily in the IGA, but just verbally, was that we really wanted to get the planning commission back up and rolling, because there had been some time where things kind of just slowed down and a lot of transitions happening. So the intent is, you know, even if we don't have an action, maybe not every month, but sometimes I'd like to do some trainings and kind of learn about what you guys want to learn about. But let's see. So kind of going back towards the end of 2024, spent the first few months kind of getting feet on the ground, figuring out where things were. You know, records are retained at the courthouse in Condon, went down there a few times. We know that we have some work to do as far as record keeping and getting things organized. So we'll be working towards that probably in the next fiscal year. But initially, one of the big goals was to look at the comprehensive plan and the development code, identify any needed changes. So that way next year moving forward, if we identify anything that we might need changed, you guys will become part of that process and we will be going through. I would suggest that we kind of take it in pieces and identify where the bigger needs are, and instead of a whole open both of the books up, but we'll kind of see how that goes as we get into this. Another thing that was identified is looking at our fee schedule and updating fees. So I've looked at it, but I need to coordinate with the Gillum County Court and find out when their next overall fee schedule update will be. So, and then I think the other big project that was identified was making the transition from what we currently have for paper forms and going towards our online permitting program that we use here at the city of Boardman, which is Citizen Serve. And we're working with the building department on that. Our building department here at the city of Boardman covers all of Morrow County and Gillum County, including all of the cities. So currently, Gillum County and all of Gillum County cities go through the state program called Acela. But then our building department made the switch over to Citizen Serve, and so all of Morrow County is on Citizen Serve. So we're hoping, we had a meeting yesterday, yeah, it was yesterday, with Citizen Serve. We're hoping that by July, we will be live with Citizen Serve. Now, with that, what I found being here just at the city is that there's a big transition for a lot of folks in a learning curve. So we may still have some paper applications that we put in, but we'll work through that process. So those are the big things that were identified in the agreement that I can think of right now. As far as projects, so because I don't really know, I mean, I can look back and see some of the things that have happened. So for me, it's all brand new, right? But what I can tell you, I've seen a lot of. So I've gotten a lot of requests for some repowers for some of the big energy projects, specifically Leaning Juniper 2A is actively repowering. When I came on board, they'd already gone through the FSEC process, and they've been obtaining their permits to be able to get their laydown yard and those sorts of things going and up and running. I think right now on my desk, I have some right-of-way permits that I need to take a look at. I think 10 or 12 of them for the company that's doing the repower for Leaning Juniper 2A. And then Leaning Juniper 2B is just getting started on their repower process. I just recently have been contacted by Pebble Springs, and forgive me, it goes by another name too, but I can't think of it. It sounds like they're going to be going through a repower process. So they were originally permitted as a local conditional use permit. So we're going to be working through that process, and they are working with FSEC to identify whether or not they need to now go through the FSEC process. So we don't have all the details on that yet. It may be coming back through you, or it may be getting bumped up to FSEC, so I'm not really sure yet. I know I'm forgetting one. There's another repower that's coming. So a lot of those projects were permitted initially in the early 2000s. So they've kind of reached their life and they're going through that repower process. So the other thing that I have seen a fair amount of is no applications yet, but I've had a lot of contacts about aggregate pits. And I think that that's coming. I mean, there's a couple things, you know, part of it is because of this repower, and there may be some work happening for roads and those sorts of things. But I think the other thing that's happening is, I think that everybody is aware now, the Amazon project in the city of Arlington. So I'm sure as that project gets up and running, we're going to see a few things out in the county that are going to be accessory to that. An aggregate pit would be one of those things. So no application yet, but I have had a handful of landowners reach out and have conversations with me about that. Trying to think if there's anything else big, you know, just a couple of smaller projects. The Gillum County Bus Barn, that was already permitted before I came on board, but it sounds like they are moving forward. They are getting their septic approvals and their building permits. So it sounds like things will be happening pretty swiftly on that. That's what I can think of. Do you guys know of anything that maybe I'm missing? That you might have a question like, hey, have you heard about this? Or no? Okay.
And
You know, and go ahead,
nothing,
Mark.
nothing comes to mind specifically for me. We did have the Barnett Road easement concern, I guess, and that's still at the county court level. So that's
Yes.
another thing that was kind of happening in my world.
Yes. And so the one that Marta's talking about, there was a developer that had reached out. And actually they just went ahead and applied for the right-of-way permit. And one of the things that I want to work with Gillum County on, and I've had some conversations with the road department, is kind of how we process those right-of-way permits. You know, whether or not I really need to sign on them, I have no jurisdictional authority as planning over the right-of-way because it's not it's publicly owned. So I have no jurisdictional authority. That's where the roadmaster is. And then of course the Gillum County Court. So they get their advice from him. We had an application that came in from a developer, and sometimes things get a little bit confusing because you're talking to one developer or one company, you know, and they're working on the same project and they have a different company name than the other one. Well, apparently in this case, there are two potential developers that are looking at the same area. So, you know, new guy here, I had no idea. I kind of seemed like it was two companies that were working on the same project. Anyways, the county court reached out and said, hey, you know, what do you know about this? And I said, here's basically what I know. And then found out that it was a little bit different. So they kind of pumped the brakes and said, hey, I think we're getting things a little bit premature on this. So that will be one of the processes internally that we will be working on, how those things come through and what sorts of things Public Works evaluates, and then the sorts of things I evaluate, and whether or not they even want my sign off on those, because it's really not necessary. I do appreciate the coordination though, because at the end of the day, a lot of projects that happen within the right of way are connecting to a project that is on property. So, you know, it's nice to be kept in the loop. Anytime you guys have questions, I appreciate Marta reached out about that. Anytime you guys have questions, please contact me. You know, if you hear of something, maybe I've heard of it and maybe I haven't. And part of that's gonna, as things kind of go along, we'll find out more that has been in process versus new projects. So it's kind of an interesting position where we're in. We're kind of picking up where things got left off and moving forward. So yeah. Okay. I think with that, the only thing that I would say, Marta, if you're okay with it, or it's up to you guys, we do have a member of the community, just one here online with us. Do we want to bump the public comment up before the training session?
Yeah, I think that'd be fine. I don't know. I know that Les is on. He said he had to get off at 6:30. So, although I think he was just going to be listening to what is going on here.
Okay.
But yeah, I guess that if there's any public comment, Les, if you'd like to be able to say a few words, now is your opportunity.
Marta, I want to know why I can't look at you. That name, Marta Michael, is not exactly you anymore. I'm just giving you a hard time.
Okay.
For the record, Les Arkin. I live and work down by Rock Creek, and I wanted to just bring up two asks, I guess, of Stephanie before I do have to jump to another Zoom meeting. And that would be the Planning Commission's role, if you see it, if there is one at this point, in periodic review. And also, in maybe down the road here, the comp plan could be put on the table and looked at by the commission, just to bring them up to speed on what that all entails and where it is at this point. Those would be my two suggestions. And I guess that's about it. I do want to welcome Lori. I think she will make an excellent addition to the team approach that you guys have always used. And it's nice to know that Gib is where he is. I kind of wonder what all that snow is behind you though, Gib, on that photograph of the schoolhouse. But
that's my
was
standard
a
winter
week ago.
background for Zoom meetings.
Oh, I like it. But anyway, that's probably all the trouble I can get into tonight. Thank you, Marta, for being willing to continue in the role. It's an important one, and I'm sure you realize that. So thank you.
Sure thing, Les. We'll talk to you soon. Thanks for jumping on.
Thank you. Okay, with that, I'm going to see if I can share my screen so that way we can get the presentation up here. Screen sharing. Okay, do you guys see the slides up?
Yes.
Okay, perfect. So now I need to move this bar out of my way somehow.
Can you drag it?
Open. There it goes. Okay. Okay, so of course we have the introductory, the pretty page here. I tried to find photos from Gillum County, so. So full disclosure, this presentation was amended from one that Carla had, that was amended from one that DLCD had. So it was a city training session and I took it and I amended it. So if any of you caught my oops at the end with my quiz numbers, I can count, I promise. The one that I sent out said 1, 2, 5, 6, I think, because I removed the quiz questions that were applicable to the city. But I corrected that. So all right, we will get started. So on here, so a little bit of Oregon background. So planning commissions came first. So that goes to show how important your guys' role is. And zoning authority in 1919. And then the Senate Bill 100 was actually the Land Use Act in 1973. That arose because of concerns about farmland lost to urban development, or what we now call urban sprawl. And then there were other concerns, of course, like coastal condominium, because of all of the development that was happening along the coastlines, sagebrush subdivision, and then ravaging rampage of suburbia, and et cetera. And fun little fact, so I shared this presentation with Les before we got started here, and Les said that he was actually there for the enactment of Senate Bill 100. So I thought that was pretty cool that he could join us tonight. Just a cool photo of Governor McCall. So standing there, it looks like he's standing along the coastline, looking at some of the coastal condominium that there were concerns about. So moving on to the slide about the state. So for those of you that don't know, LCDC and DLCD, those are the two state oversight boards. DLCD is the Department of Land Conservation and Development. And they play a major role for us because any time that we have an amendment of our comprehensive plan or our development code, any zoning amendments, those sorts of things, we have to notify DLCD before we have our first evidentiary hearing. DLCD can provide comments and guidance in those amendment processes. So LCDC and DLCD, they have the role of setting the land use policy of statewide significance, the goals and rules that were implemented that we'll get into here in just a minute. And then initially acknowledged our county plan. They acknowledge all city and county plans. So every city and county across the state is required to have a comprehensive plan. And that comprehensive plan is what drives the development for that area. They help enforce those goals. So DLCD, if we were doing a comprehensive plan update or a code update that was incompatible with our comprehensive plan or incompatible with the statewide planning goals, then that's where DLCD would provide us guidance and say, hey, this isn't compatible and you need to think about how you can either change this or dismiss the idea. And then lastly, they provide technical assistance. I can't tell you how many times in the 11 years that I've been doing land use planning that I've reached out to folks at DLCD. So for those of you that don't know, there are regional representatives at DLCD. They're kind of like the point of contact for any questions that we might have. Our regional rep here is Dawn Hurt, and she's been a really great resource since she started a few years ago. And then they have specialists. So if it's farm and forest, there are farm and forest specialists, or wetlands planning specialists, all sorts of specialists across the LCD. So they're very helpful for staff and can be a really great resource if planning commissioners have questions as well. Okay, so cities and counties, our responsibility here at the county is to address the local vision and needs. So the local vision should be clearly outlined in the comprehensive plan. The other thing that we would do is adopt and amend the plans and codes in compliance with those statewide goals. So one thing that Les brought up is the amendment of our comp plan. Here in the near future, we will be looking at it to see if there are updates that are needed and what sort of vision maybe it has changed since it was last adopted, or maybe it's working out really great. Those sorts of things. Staff are also responsible for enforcing the codes and ordinances. So if there was a compliance issue where somebody was already violating the code, we would be responsible for stopping that or helping the community member or developer in coming into compliance with that. Then we make land use decisions. That kind of goes hand in hand with the last one. We would, every time that there is a development that's happening, the coordination with staff happens, and we make sure that the code and ordinance is being followed in those decisions. And so that code and ordinance, that is part of the Planning Commission's role in making sure that a code is effective and make recommendations as needed to the board, the county court, for any amendments, which would be legislative. Okay, the next slide identifies the statewide planning goals, and I sent you out some handbooks. One of them was a planning commissioner handbook, and then the other one talked about the statewide planning goals in a lot of detail. There are 19 planning goals, but really the first 14 are the ones that are applicable for Gillum County. Goals 15 through 19 are more applicable to the Willamette Valley and the coastal regions, so we don't have to deal with those here. What happened? Here we go. So goals 1 and 2, those are our process goals. So those basically tell us how we need to operate. Goal number 1, probably the most important goal, is citizen involvement. Citizens are the most, I mean, they're the ones that are affected by our decisions. And they should have a voice in all the processes. So as you go through this, you'll learn that there are several different decision types. As staff, we break them down into 4. The first decision type is ministerial. That's something where it's what we used to call like an over-the-counter permit. Somebody would come in and say, hey, I have this shed that I want to build, for example. And we could say, yep, that meets our code and it's a use that's allowed outright in your zone. And so it's a ministerial decision. The second one would be an administrative decision. And that one is a little bit more involved. There's set standards within the code, and so it's not as clear cut. It's still a staff decision, but there is more work to do on our part. According to our code, we have to do surrounding landowner notice and provide the opportunity for that input. And then quasi-judicial, that's where your role comes in. The quasi-judicial role, the citizen involvement for that is we do the adjoining property owner notice, and then we also put out notice in any ways available. So for me, I put it into your guys' local newspaper, and then we would try to get the word out best we can. So I'm building a distribution list so that way community members or other agencies that may have an interest would receive a copy of the agenda for Planning Commission. The last thing that we do on that is we provide affected agency notice. We often do that for the type 2 decision as well. It's a little bit more in depth in this type 3 because what they're doing is they're providing comment to you and not directly to staff. It would come through staff, but it would be for your review. And then the type 4 is a legislative. That one has a Planning Commission recommendation. And then that recommendation would go to the county court for their decision. Legislative is anytime that we're changing anything that's been previously adopted as far as codes or ordinances or zones. And each of those citizen involvement is really important because the citizen always has the opportunity to inspect or review our records or provide comment in the process. Goal number 2 is land use planning. That's the process goes like that lines out everything that we do. That one's always changing. Okay, so goals 3 and 4, those are our rural goals. These goals here are applicable at the county level and often not so much at the city level. So we have agricultural lands and forest lands. It's pretty self-explanatory. Gillum County doesn't have forest lands to speak of. So we're primarily dealing with agricultural lands. The goal behind these is to protect the value of those agricultural and forest lands and the natural resources that are available with those. So that is part of the reason why what we do is really important and can often be complicated is because we're dealing with goal 3 and there is a really heavy protection at the state level for agricultural land. So somebody can't just come in and do whatever they want. They need to make sure that they're meeting that goal. And if not, then there's a process that they can request an exception to that, which can often be very difficult. Okay, so these goals here, which are going to get us a little bit out of order, but they are what we call the development goals. So goal 8 is recreation, and that one is applicable in both cities and counties, and it is the county's idea of how they want to see recreation happen, also keeping in mind the other goals, so that way we're not interfering with them as well, but to provide an opportunity for citizens to recreate. Goal 9 is economic development. Different than recreation, but sometimes recreation can be part of the economic development of a city or county. Economic development often focuses more on some industrial and commercial development and how the economy is the driving force behind the economy and kind of the local flavor. This is one of the things coming from Morrow County after 10 years that we kind of saw a shift over at Morrow County in this. And I think that Gillum County may see a little bit of a shift as well. The biggest economic drivers in Gillum County right now that I've seen are renewable energy development, the waste management site, and it sounds like some data development will be coming in as well, which can be a little bit of a transition. So the purpose behind this goal is where the county would like to see economic development happen, and how that happens in a way that has the least impact on the other goals and the citizens of the county. Goal 10 is housing. It's pretty self-explanatory where housing will be developed and what the need is. Oftentimes when some of the other goals, as things develop and those things happen, the need to change and update the housing goal can be affected as well. The other 3 goals on this are sometimes a little bit more applicable within the cities, but still have an impact on county. Public facilities, of course, there are public facilities out in the county. Oftentimes when we think of public facilities, we're looking at wastewater and water facilities. Some of those resources are out in the county as well. And then places where the public can gather as well. Transportation, we still have impacts from transportation, of course. There are a couple of major highways that run through Gillum County. And we have some arterial collector roads, and then of course we have some local collector roads as well throughout Gillum County. So, and then urbanization. So this one isn't really our problem until it becomes our problem, right? So around every city there is an urban growth area, and that has been identified as future expansion area. A city could come in and ask for a urban growth expansion. In that case, they would be working cooperatively with the county to identify those areas. And because Gillum County is predominantly farm ground, they would also be taking a Goal 3 exception in that. So this is urbanization, is the development of urban areas in a orderly fashion to prevent urban sprawl. And then this last slide talking about our goals are our resource goals. These ones are really important in Gillum County. So we have our natural resources, scenic and historic areas and open spaces, which is Goal 5. So natural resources is pretty much everything. Often when we see Goal 5 at the county level, folks will come in and they'll ask for a Goal 5 exception, particularly for aggregate resources. When they're asking for that exception, they're asking for protections from those rules and how it could impact their development. Goal 6, air, water, and land resources quality. So at state level, we have Department of Environmental Quality. They provide regulatory oversight over much of the air and water resources. But sometimes those come into play when we start talking about industrial development, any sort of waste or any of those things. And then areas subject to natural hazards. So every county is required to have a natural hazards mitigation plan. and identify what would happen in the event of a natural hazard and how we can mitigate. So we identify those areas that are subject to that, to influence that. And then goal 13, probably one of the most important goals in Gillum County, is energy conservation. So any renewable energy development that happens, or other ways to preserve and conserve energy. Okay, so that gets us through all the goals. Does anybody have any questions so far? Or input or anything? Are we still
Thoughts of
live?
some kind. We are still here.
I did have a question, and it can wait till later too, but in line with what Les brought up and what I was reading earlier, when was the last time we did a periodic review, and is the county's comprehensive plan available on their website, or where can one access that to get a look at it?
The comprehensive plan is available on the website. I can't think right off the top of my head how to navigate to it, but there's
That's
a
okay.
link to our development code and the comprehensive plan, and they're right next to each other.
Okay.
And I can also send it to you. I
No, that's
don't
okay.
know when the last periodic review was, but when Les was talking, I made a note so that way I can check.
Okay.
In the time that I've
Thank you.
been here, and Gib, maybe you can speak to this, in the time that I've done this, I've not seen one.
No, we've just updated a couple of zones here and there, mainly in the urban growth boundary on Condon.
Right, and we did a major update when Susie Anderson was our planning director. So that gives you an idea of the time frame. It
Yeah, that was
was,
a little while ago.
yeah, it was several years ago that we did, but then we went through COVID. We went through a lot of things that kind of set us back. So,
Right.
but at that time, that's the last time we had a real hard review of the whole dang thing, because it was arduous. It was quite a rough go.
Okay, good to know. And for your reference a little bit, the periodic review, thank you for sharing that, Erin. In the chat, she shared our comprehensive plan. The periodic review is a process that we work cooperatively with DLCD on as well. So I will check into that and see what I can find, if anything. If not, then I can reach out to DLCD and ask them when the last time was. So
It's probably going to be a significant time responsibility.
it
But
is, and what I will tell you, and I think this is pretty common, especially in some of the rural areas where there are not a lot of staff. Periodic reviews don't happen as often as what we would like. So we need to make it a priority, and that can be hard with the day-to-day, but we'll get with it. Okay. So the planning commission tools. This slide kind of identifies what we're going to talk about, so we'll skip right past that. The roles of the planning commission. So as I stated, you are the quasi-judicial decision maker. Planning staff are the experts on the plan and code, and often the initial contact for the public. Not always, but it often is. One of the other trainings that we'll be doing in the near future, we'll talk about ex parte contact, and that's important because as your role as a quasi-judicial decision maker, you have to come in with an unbiased and uninfluenced opinion of what any development might be. So that's just important for noting in case somebody comes up to you and says, hey, I'm working on this development. I really want to get your take on it. Well, if it's going to come to me, you probably need to talk to staff. So we can provide anybody any information. And then if it needs to go to you, then we'll send it on up to you. So we draft and present the staff report and recommendations. That doesn't mean that you're always going to go with our recommendation, but usually we're evaluating the code, and the staff report will delineate the reasoning for our recommendation. And then we are the resource during the public hearings. Often we are the ones that respond to the questions, assist in the process, and then prepare any findings and any modified conditions that happen. The other one is the government attorney. The government attorney is the resource on legal issues that provides input on the process and assists in developing the conditions and findings. A lot of times we don't need the attorney unless things get really contentious or they're really confusing, or it's just really unclear which avenue we should take. One of the benefits that we have right now with the current agreement is that I have a couple of resources for attorneys. We have a city attorney here and the county has an attorney. So whichever is more relevant would be the one that we would reach out to. So. Okay, so what commissioners need and expect? So from the planning staff, what you should expect from us is that we provide you with well-prepared and understandable staff reports, and then we present the application criteria and options that are available. You should expect that we have the ability to explain the code language and how it has been applied, and then deliver and understand input from departments and agencies. So if there was input that came in, we should be able to interpret it and get it to you in a way that makes sense. We should be able to answer your questions fully, accurately, and objectively, or commit to get those answers to you. And then provide guidance if needed or appropriate. And then we would always show respect to the commission and public, and then identify any need for follow-up. So if we ever don't deliver what's expected, let Carla know. So what you should expect from the city or county attorney is accurate legal advice. So if there were a contentious issue that was coming and we knew it, we were getting a lot of public input or something like that, then we would reach out. In that case, it would probably be the county attorney that we would reach out to and say, hey, do you want involvement in this planning commission hearing? And then that way you have the opportunity to ask for legal advice. In the case that there wasn't an attorney that was present at the meeting, what we can do is do a continuance or something of that sort, and you can direct those questions through staff and we can get that legal advice. The city attorney should be able to provide guidance on the process. So particularly if there's any conflicts, bias, or continuances, which we'll get into a little bit later, and then the conflicts and biases in another training. The city or county attorney should be a resource to the chair to respond to any issues as they arise. Like I said, they're not always going to be at our meetings, but we can always get back to them if needed. They would assist in maintaining order in the case that things got out of hand during a public meeting. And then they could identify and propose improvements through training, rule revisions, or language improvements in codes. So when we do any of those code updates, it would likely be reviewed by one of the attorneys. So that way we can make sure that we are consistent with the Oregon rule and statute. Okay, so what we need from you as commissioners. So know the plan, code, and local rules of procedure. I'm probably going to, and I should be expected to know the plan and code better than you because I'm applying it every day, but at least have a general concept of it, even if we have to get back to a decision at another time with a continuance or something of that sort. Prepare fully for the meeting. So be present, read your packet beforehand, which we will always get to you at least a week in advance. Ask questions in advance would be preferable if you have something that's minor, but sometimes it might be something that you want the other commissioners to know about. So ask questions during the meeting as well. And then suggest any improvements. So if you have an idea for the meeting and you think that maybe we should be, changing up the, maybe public comment should be first, or maybe it should be last, let's talk about that. And then if there's any improvements that staff can make in the presentation of anything to you as well, or maybe the improvements in when and how the meetings are. So listen carefully to all, respect the staff, the applicant, the audience, and fellow commissioners equally. Oftentimes, meetings are pretty straightforward and can be pretty simple, but in the times when things get contentious, it can be really hard to maintain a sense of composure. And so, I mean, we just got to try our best to represent the county and our role that we can. Preserve the public trust in the process. So declare any conflicts, bias, site visits, those sorts of things. Like I said, we'll get into that in another training. And then make open decisions. So we're not making any decisions behind closed doors. If I send out an email, try not to reply all. If it's something where it's part of a public hearing, there's a decision to be made, I will more than likely blind copy everybody and try to prevent a reply all, but just keep that in mind. So that way, if there's any discussion that happens, particularly around a decision that will have to be made, that we're not discussing it in a reply all email. You're welcome to reach out to staff at any point in time if you have concerns or if you have input on a decision beforehand. That's fine. Communication between staff and you is fine. But anytime that as a board you're making a decision, we need to be completely transparent about that. And then lastly, understand the law that applies, including the public hearing process, conflicts of interest, and then the Oregon Public Meeting and Public Record Law. So the statutes are identified there, and then those will be some of our trainings that we go through as well. Okay. Hearing procedures. So we kind of talked a little bit about the hearing procedures. These ones are the ones that you would have an active role in, the legislative and quasi-judicial. The difference between the two, so legislative is the adoption of the law. So the Planning Commission would recommend to the county court. That recommendation could be approval or it could be denial, whatever the recommendation of your board would be. In a quasi-judicial process, the Planning Commission applies the existing law and is an impartial tribunal. So in a quasi-judicial decision, you are the decision maker. It could be appealed, and in which case it would be appealed to the county court. But it would be your responsibility to apply the law as it exists. And then a legislative would be to recommend any change of that law. Legislative is less restrictive and allows ex parte contacts. So that is something that we would get into later, but the notice is prescribed in quasi-judicial and findings are required. Okay, so the legislative process, less procedural restrictions apply. So from a staff perspective, quasi-judicial, ministerial, and administrative decisions, we're held to really strict timelines. There are things that we have to factor in, complete applications, those sorts of things. Legislative process, it's less procedural, but we're still following somewhat of the same process. There is no timeline on it, so we can take as long as we needed to make any of those legislative updates. The decision makers sit as lawmakers. So in that case, it is the county court. Information used in making the decision may come from many sources. So in that case, there would be, you could go out and you could talk to the public. If we're thinking about updating our code, you're going to want to know what the public is thinking about it. So in that case, it would be allowed. Findings are less specific, but some are needed. So when we're talking about findings, which we get into later on in this training, often we're identifying the law as it currently applies. So that's why the findings are less specific, because we are creating new code. Adequate findings or accessible materials in the record must show applicable criteria were considered and applied. And in that, we need to make sure that we are following our comprehensive plan, or in the case we're updating our comprehensive plan, we would be following the guidance in the statewide planning goals.
How often are codes created? Is that usually by a county or is that state?
The local code is by the county.
Any idea? I mean, I don't know, chime in. In the time that I've done this, we've not created code. Is it common?
I would say it's not common. Most of the code was created, wasn't it, back in the 70s, and what we're doing now is just amending and evolving it.
Yep, that's pretty accurate. And oftentimes you identify the need for a code change when it's sad to say, but when development happens. So when something comes in and it's in direct conflict with the code. Now, the exception to that is every couple of years, the Oregon State Legislature, which is in session right now, they are often changing the state laws around land use. And so if something comes down and it directly affects the way our code is written, then we have to apply that change. So it could happen every couple of years, but it just really depends on what legislature has. But in that case, oftentimes we just take that one specific area and we apply it as needed in there. Carla's in the room now, so I know you guys can't see her, but the question that just came up is how often is code changed?
Oh, well, code can change as often as is needed. And code changes can happen by request of an individual. So a landowner or a potential developer. It can be done at the request of staff. It can be done at the request of either the planning commission or the county court. So I will be honest, I don't know the Gillum County Code intimately, but there's usually somewhere in the amendments chapter or the chapter that kind of talks about how amendments happen. It sometimes will provide guidance about how amendments can be initiated. Some communities are very restrictive about how amendments can be done. Others are very open about it. So to answer that question, that's a general answer. To answer it specifically, I'd have to go look at your development code and see what it actually says.
The other thing that I would add is often what we will see when it comes from a developer standpoint is the request for a zone change, which is part of the legislative process as well. So if somebody came in and they wanted to change the zoning on a piece of property, it would be a legislative process.
Yeah, so what page are you guys on? How much have I missed? I apologize.
I don't know what page number we're on. My print doesn't have it. We're going to quasi judicial process.
Okay, I'm kind of page 17.
Okay, so the quasi judicial process, this is your primary role usually. You are the decision makers. As we talked about earlier, Articles 5 and 14 of the US Constitution require due process. So with that, we would be bringing any information to you and the, what would you say about due process?
Yeah, due process is really where people are allowed to be heard.
Yeah.
And really, whether they are the applicant or somebody who's in support or an opponent, or even somebody who's just asking that neutral question, hey, how might this impact me? They all have an opportunity to ask those questions. And I think that's what's really important about a quasi-judicial hearing is that, it's incumbent upon the chair, the whole commission, but in particular the chair, or in some cases, the person running the meeting, if for some reason the chair's not there, to make sure that people are given that opportunity to say, hey, I don't understand this, or how might this impact us? And I think an important thing to remember when you're in that process is that in a and I just broke all these rules tonight with what I was just doing before I got in here, but the planning commission chair's role is to make sure that the audience is heard, whoever that may be, and to make sure that you're managing that hearings process so that questions are directed to you as the chair and as the body of the planning commission. So, I sometimes kind of probably do too much hand holding and try to answer too many questions when staff really should step back. When you're in that actual hearings conversation, the planning commission chair is leading that conversation, and questions should be going to them. And you don't necessarily have to answer every question asked. And then there is an opportunity for staff to respond to those. And you can engage with staff and have them kind of respond in that moment, or you could hold all of those questions and have staff respond later. So I think another really important part about being the planning commission is the first sentence there says decision makers sit as an impartial tribunal. I think that's another important component. It's that impartiality. And having worked in a lot of small communities, we all know each other. And oftentimes we're related to somebody else in the audience. And that sometimes makes it, I don't want to say it makes it difficult to be impartial, but maybe, you know, it can create the sense that maybe somebody isn't being impartial, or maybe you're giving deference to someone. So, you know, we do need to find that way, that mechanism by the way all the parties are treated fairly. And sometimes the parties are, you know, sometimes the questions that come in are difficult, or maybe there is real concern about an action, and people's emotions can get the better of them. And so again, I think a real skill for a planning commission chair is figuring out how to handle the emotions that might happen in that kind of an environment. You want to say, it says here too, that allow all parties to know what the decision makers know. So again, this gets into that ex parte contact. If you've had contact, you need to disclose that contact. And if you've done a site visit, you need to disclose that. Or if you happen to live near the property and drive by it all the time, you should share that information so that there's no, so that everybody knows what that comment, it's just everybody needs to know what everybody knows. And sometimes it's hard to remember that. But, you know, at the beginning of a hearing, when the planning commission chair reads the opening statement and it talks about ex parte contact or conflicts or bias, think about it. When you read the packet, go, gosh, you know, I know this applicant, or, you know, I drive by that property every day, or, you know, the other week I saw somebody doing something on that property and it looked a little odd. Maybe it's related to this. And those are the kinds of things that it's okay to call staff and say, hey, I saw this, or I know this, and I want to make sure you're aware of it as well. So that's the disclosure part of that impartial tribunal. Yeah. Oh, more things about impartiality. And again, the second bullet here is really important. It says the process allows information placed before the planning commission to be challenged. That can be that could be the applicant challenging something in the staff report. It could be an opponent challenging the application itself. The last bullet, to challenge information, the parties need to know what has been submitted. And that's why we do a staff report, and that's why we put attachments to it. Make those things that have been submitted available and put it as part of the record.
Oh, no.
So there's a lot of land use law that's happened over the past, I don't know, 50, 60 years. Fasano goes back to 73. What's really interesting is some of the most important land use cases, legal cases actually come out of, guess what? The state of Oregon. So Fasano really kind of put into place what's required in a quasi-judicial proceeding. People have an opportunity to be heard. They're able to present and rebut evidence. It has to be an impartial tribunal. The decision has to be based on the record, and the decision has to be supported by adequate findings. Those are things that staff kind of work on all the time. That's what we try to do. We try to make sure that the staff report we provide to you is responding to the criteria that the applicant has submitted evidence. And if somebody else submits evidence that is contrary to that, it's not the staff's determination about which evidence is right or wrong. That's actually in your court. So if I submit evidence and say that the sky is blue, and the opposition submits evidence and says, no, today the sky is gray. Well, at the end of the day, it's the planning commission in your decision, which you're going to base on the record. You're going to decide if the sky is blue or gray, not staff. So you look at that evidence. You are the impartial tribunal, but at the end of the day, you get to make the decision based on the record. So you get to decide if the sky is blue or gray. So I'm going to stop here for just a second, just to ask if there's any questions.
Nope, great information. Thank you.
Yeah. So this next one is about procedural items and requirements. And you have a procedure chapter in your development code. And you know, one of the things that we are working on and we're working toward is making sure, you know, we're going to do some audits of the development code and the comprehensive plan and try to figure out, you know, are there things that need to be updated? But most of these procedural items are outlined in statute. So you have to provide notice. I have recently learned that most counties and cities have a published requirement. So we all publish the hearing, upcoming planning commission or county court or board of commissioners hearing in the newspaper of local record. Interestingly enough, that's not actually required in statute. Now, adjoining property owner notice is. And most communities want to make sure that the community is aware of what's happening. But there's been a lot of debate lately about the cost of publishing and whether or not community members are actually reading public notices. I do work in another jurisdiction, and they removed the publishing requirement from their development code when they recently updated it. And it actually surprised DLCD staff when I said, you know, there's not actually a publishing requirement in the statute. And they said, oh my gosh, you're right. And I think everybody has just assumed that it's there for a really long time. Now, I'm not necessarily advocating that it should be removed from your procedural requirements, but it's a consideration to be made. Also, procedurally, there has to be a staff report, and your both statute provides some requirements around this, and your development code may provide additional requirements or more stringent requirements. What has to be in a staff report, when it is available, and who receives it. Documents submitted must be available to the public. Now, in today's world, we can put a lot of stuff on the web and place it on the Planning Commission webpage, you know, as long as there's support to do that. But that wasn't always the case. And so as technology changes, we have to make sure that we're changing our development code to be consistent with what we actually can do with technology. I don't know if historically the Planning Commission chair has made a statement as part of your Planning Commission here proceedings. But if you haven't, we need to initiate that. If you have, we probably want to look at it and just make sure it's consistent and current. And then the right to a continuance is interesting. There's been a lot of case law on that. And if somebody requests a continuation at that first hearing, or before the conclusion of the first evidentiary hearing, they are given that right. Now, that continuance does not have to be to a full hearing. It could be to a process by which you allow written evidence, testimony and evidence to be submitted. But either way, a continuance must be granted in that situation.
This is Marta, and we have always done the opening statement that was referred. So that's something that has been traditionally included in all of our hearings. Plus, we've done the continuance on occasion. So
perfect. Cool. Yeah. Okay. Yeah. So we'll work with Marta. We should work with you and make sure that opening statement is still adequate and is covered by current law. So yeah,
that would be, and that was something that was always supplied to the chairperson by the director person. So
okay.
We were very confident that it was up to date at all times. So
yeah. And my guess is that it was and still would be, but I think it's a good thing to take a look at.
Absolutely. Yep, I'm with you.
Yep. Okay. So now burden of proof. So so the burden of proof is not on staff. The burden of proof is not on the planning commission. The burden of proof is on the applicant, the proponent. They have to show that all elements necessary to grant the proposed application have been met. And they do that by submitting that complete application with substantial evidence. So they can't just come in and say, well, I talked to a traffic engineer and they said that we'd be just fine. That's not substantial evidence. We need something that is stamped by a traffic engineer. I mean, if a traffic analysis is required, then we need to have that in the evidence. So that's how you meet that burden of proof. Again, it is not necessarily on the next slide. It is not necessarily, again, it's not staff's position. It's not staff's responsibility to respond to all those issues that are raised by opponents. And the applicant should not reply or respond or rely on staff presentations. So you'll remember in your process, the applicant gets to present, and then you ask for proponents to present, and then you ask for opponents to present, and then you ask for neutral parties to present. And the applicant always has the final rebuttal. They get to be the last one who speaks. And if somebody has raised a question or has introduced evidence into the record that is contrary to the staff report and the evidence they provided, the applicant needs to rebut that. If the applicant can't rebut it at that point, it is in the applicant's benefit to request a hearing, a continuance to the hearing, to be able to provide that evidence to support their claim. And if an applicant provides new information at the hearing, particularly in that rebuttal, if it's not going to be continued with more opportunity for the public to review it and respond to it, the public has to be given that chance to rebut it. So if the applicant provides additional testimony, I would always encourage you to do the proverbial timeout and have that conversation with staff about, should we be continuing this hearing? And the answer would be absolutely yes. Now, and again, it may be that you do that in a typical 777 where people have, and we can talk about what that means if there's questions, if you haven't used that mechanism before, but that gives everybody an opportunity and always ends with the applicant having the final say. Okay. Evidence in the record must be the basis of the planning commission decision. So again, if the information or evidence in the record is that the sky is blue or the sky might be gray, you can't then make a decision that says the sky is orange. You have to decide if it's blue or gray and pick one. So your decision must be based on the information, the evidence and testimony that is in the record. And this definition of evidence is important. It's facts, documents, data, or other information offered to demonstrate compliance or non-compliance with the standards believed by the proponent to be relevant to the decision. Now, let me say something about that, because I don't think it covers it in another slide. So evidence, it says standards believed by the proponent to be relevant to the decision. One of the things the opponent can do, the person who's opposed to this, is they can raise issues about whether or not the appropriate standards are being applied. So let's just say we're approving a wind farm and we're using solar farm standards. And an opponent comes in and says, you're using the wrong standards. Well, that's a pretty blatant, obvious response that, yeah, we're using the wrong standards. But maybe it's, hey, you didn't apply, this is a commercial development and you didn't apply the commercial parking standards in your code. And if they're right, then here again, we need to kind of halt the process, continue the hearing, let the applicant respond to that, let the staff build it into the staff report and bring it back the next month for further review. So that definition of evidence is really important. A standard is believed by the proponent to be relevant, but again, the opponent can say, you're not using the right standards. And that is another thing that is offered in statute and in the process. So administrative law standards, do apply. And so when you're dealing with evidence, is the evidence the kind a reasonable person would rely on the conduct of their own affairs? So this reasonable person piece is really, it's really kind of interesting. And I've dealt with a couple of different appeals where the reasonable person came into play. One in particular was a noise complaint that Morrow County had on a wind farm. And in front of the planning commission was like, why are we dealing with this? And at the county court level in Morrow County, they actually came up, they made a de minimis decision. And they did that because they relied on the reasonable person component. They said that a reasonable person would not, and I don't remember enough of the specifics to probably quote them here, but it was interesting how we ended up landing on what would a reasonable person, what conclusion would they make in this situation? Because again, we had a situation where we had competing experts. And so expert A was saying, oh, no, that sounds like a freight train. And the other expert was like, well, no, not really. And so the county court said, hey, a reasonable person, and again, I don't remember all the specifics, but it was really interesting how that reasonable person component of this came into play. You do have discretion to determine whether evidence should be accepted. You don't have to accept it. If you don't think it's appropriate, if you don't think it's applicable, you don't have to accept it. You can also and should consider which evidence is relevant, reliable, trustworthy, and strongest. And you may find that some you don't think is reliable, others you might. And it's important to have that conversation. And particularly the more evidence in the record, I think the more you need to make a statement about what your sense is of the evidence and the testimony evidence that you're seeing. And again, substantial evidence that, again, the decision must be based on reliable evidence in the record and the quantity must be substantial. So again, blue sky, gray sky, who submitted the picture? That's probably the substantial evidence that you're gonna rely on. The other guy's just telling you it's gray, but the blue guy submitted the picture. Yeah, this evidence may not be voluminous. You can at some point go time out. We don't need 39 different reports to figure this out. And I think the next bullet there may be inconsistencies in evidence presented. It seems like all the time. And the more contentious the case, the more evidence you're going to get and the more it's going to be inconsistent and the more they're going to try to bury you in a record. So again, you can get to the point. And the other thing that's really interesting in today's world, people like to send you a link and say, we want you to put this item that's linked in the record. Well, that link may not be sustained. And so there should be a clear determination by the planning commission that evidence that's provided in an email with a link, you should be really conscientious about accepting it. If they want to submit the article, then they should print the article, they should make a PDF of it, and they should submit that. It's just cleaner. And then this last one, it says you should determine whether the evidence in support of the decision, when viewed in light of contrary evidence in the record, was sufficient. And here we go again, that a reasonable person could rely on it. So again, if you go back to the blue sky and the gray sky, was the picture sufficient? Was the picture clear? And could a reasonable person rely on it to determine that the sky is blue? So on appeal, the standard is that a reviewing body will not disturb a decision based on substantial evidence, even if there's conflicting evidence in the record, and the findings must be sufficient to show why certain evidence was believed over other evidence in the record. So again, why did you agree the sky was blue and not gray? You need the findings. So when you're deliberating, you want to make sure, particularly when you've got conflicting evidence, that staff know so that they can capture in the final staff report and in the final decision why you picked blue over gray. They submitted a picture. The picture was clear. The sky was clearly blue. In fact, we would call it cornflower blue. Those are the kinds of things that when you're deliberating about why you believe certain evidence over other evidence, that's what the staff is going to rely on in drafting your final findings and your final decision. So I think before I get into this one, I do want to say that as much as, you know, planning commissions make most quasi-judicial, planning commissions make the quasi-judicial decisions. When a quasi-judicial decision, and let's say you've gone through the whole blue and gray, and you've picked the blue sky because you think you thought it was substantial. But what's interesting is on appeal, if the county court does not clearly delineate why they have agreed with your determination that it was blue, if the county court's decision is further appealed to LUBA, LUBA's going to look at the county court decision, not your decision, because as the elected body, they have more authority than you do as the appointed body. And when it comes to interpretation, what they say is what they say goes. And as long as they've made that interpretation consistent with your development code, your comprehensive plan, whatever the standards are, LUBA may very well, and in most cases, they will agree with the county court decision. So if somebody appeals that decision about, well, why we don't agree, we think the sky was gray, and they appeal that, staff's going to want to make sure that the county court understands your decision-making rationale and reiterates that rationale in the county court's decision, because when they interpret that decision and it gets appealed to LUBA, it's that interpretation that becomes, for all intents and purposes, law within Gillum County. The sky will always be blue, if that makes sense. Anyway. Right, examples, hearsay and signed petitions. Signed petitions are just that, they're signed petitions. You can place doubt, and you can ask whether or not the reliability and the relevance of it. The best practice here is a good one. You should accept the evidence conditionally. You should allow rebuttal. If there's objection to evidence, the planning commission can accept the evidence and decide later in the hearing before making a decision whether to admit the evidence into the record. And, you know, we don't always have our city or county attorney available to us, but if those are the kinds of things, if we know that a petition has been submitted, or if we're concerned about the relevance of something that's been placed in the record, we can have those conversations beforehand and have a good legal interpretation available. And again, in most cases, this isn't a concern. It seems like the more contentious the action, the more often this kind of stuff comes up. Oh yes, raise it or waive it. You have to, the opponent has to raise the issue at the time. And so this is also referring back to properly issuing notice. And it says here, by complying with the notice requirement, that a local government benefits because participants must raise issues during local proceedings. Any issues not raised or waived if the matter is appealed to LUBA. So you can't, after a decision is made, come back later and go, well, you didn't ask all the right questions. Well, if we did proper notice and we don't have a procedural issue, then if you didn't raise that issue, you don't get to raise it later. And again, we want fewer appeals to the Land Use Board of Appeals because they're just a nightmare.
Okay, so next we have findings. So do we want to pause if there's any questions?
Yes. Yes.
Any questions or comments?
I don't have any.
So findings, that's your staff report. Sometimes they're called findings of fact. Sometimes they're called findings of fact and conclusions of law. You know, different jurisdictions kind of produce them differently. Again, have we even done a set of findings yet for the Planning Commission in Gillum County?
We have not.
We have not. So, when I first started in the planning field and when I first started writing findings, an awful lot of the staff reports were a couple pages long. And by the time I left Morrow County, staff reports were probably on average, the written reports were probably at least 10 pages, if not 15 or 20. And not because we wanted to be over regulatory, but because we felt it was important for not only the county, but for the applicant to really understand what the requirements were and how they could meet the requirements. When we determined that maybe a standard was not applicable, you can't just disregard it. You have to define why it's not applicable. So, yeah, I think findings are really important, and the more contentious a decision, the more important those findings are. So again, we're going to learn more about how findings have historically been done in Gillum County. You know, I knew Susie and I knew Michelle, and I know they both tried really hard at doing their jobs in the best way. And, you know, occasionally both of them would call and ask me questions, and I would provide them some information, and I provided both of them draft findings over time. So I'm not overly concerned about the findings that have been done in the past. But I guess I'll put you all on notice. They're probably going to look different going forward in the future.
So what I've seen of Michelle's findings, at least in the recent years that I've looked at, is they look really sufficient, actually probably overly adequate. I would say they look really good. So
Good.
I've used a couple of her examples in drafting findings for some of my ministerial decisions. Like coming up, I think I have a cell tower that I have to make a decision on, and some changes to that. And I pulled open some findings that Michelle did in the past, and they look, she covered every base, so she was doing a good job.
Good job. Good to know. I'm not surprised by that.
Yep.
I would say, this is Marta again. I would agree with Stephanie. I think the findings were extremely thorough, frankly, and we relied on those and trusted them. So it was a great benefit to the group.
Yeah, that's good. That's good. Those are good, kind words. Yeah. Okay. So final findings. The final order must be legally sufficient once the decision is made. And this is important too, because you don't have to approve every land use application that comes in front of you. You can deny them. So when you're approving it, you have to address all the criteria. When you're denying them, and I have to say denial is not something that I've done very often, but I have done it. And findings are still required. You still have to write the findings, but a failure to meet any relevant approval criteria is enough to support denial. Findings only need to address the criterion that is not met. So let me think, if I can think back to when we denied something. There were two items that we denied at the county when I was at Morrow County. They were both near Aragon, interestingly enough. One was for an aggregate site, and the other one was for an expansion of use on a commercial property. And for the aggregate site, that was very contentious. Went to LUBA once, came back, was going to go to LUBA again, and the applicant finally decided not to fight it. And the Board of Commissioners, I think they were still county court at that point in time, they denied the aggregate site. And it's interesting because they did that. Staff actually was supportive of the application. The original findings were findings in favor. And because it was a goal 5, it was a planning commission recommendation with the county court making the final decision to approve it. And it left the planning commission with a recommendation to approve. And it was in front of the Board of Commissioners that it changed from an approval to a denial. And it started out with a petition for the denial. To this day, I'm not sure that there was really adequate evidence in the record to approve the denial. But we got there. It was pretty contentious. It was not a fun, it was not fun. And I don't remember the circumstances around the other denial, but the applicant knew when he made application that we were going to deny, and he made application anyway. And again, I don't remember the circumstances behind it, but it's important. You still have to do those findings, but you only have to really only address the criterion that is not met. And if that's the basis on which you're denying, you can leave the rest of it. You can show what the criteria is, deal with the findings for that criterion, make your decision to deny. 150-day rule. So I think I should let Stephanie talk to the 150-day rule.
Okay. So statute requires that final action on certain applications or the action must be within 150 days. That includes the procedure, any exceptions, and then a refund of fees is where statute talks about it. This is particularly important, as I talked about earlier with the legislative decisions, that is not within this 150-day rule. So all the other applications, the final decision at the local level, including any appeals, must be made within 150 days. We have an additional 30 days of staff at the front and up to 30 days to deem an application complete. So if somebody makes an application, we determine everything they have within 10 days and we deem it complete, then that's when the 150-day time clock starts. If it takes us 30 days to get that completeness, then that's when the 150-day time clock starts. So for actions that would come in front of you, that would include any process, any notices, any hearings, including continuations that you may have. And then if appealed, the county court must make their decision within that 150 days as well. There are some exceptions. An extension can be granted by the applicant through a written request. So if there were a decision that were to be on the table and you have agreed that it may take a little bit longer, say maybe somebody's doing an engineering study or something of that sort because an issue was brought up during the hearings process, we could ask that the applicant waive that 150 days and grant an extension on that to allow for time to get that engineering study back. Now, that's not to say that the applicant would have to extend it. They could deny granting that extension and we would have to make a decision based on the evidence that we have in front of us. So what happens if a county does not act in 150 days? So a few things happen. Anybody could take it to the circuit court and the county would lose jurisdiction to make that decision. The circuit court would make a decision on that. If they find that the county did not make that decision within that 150-day time period, the court may order approval without the detailed conditions that may have been required had we made that decision beforehand. And where it talked about the refund of fees, the court may also order a partial refund. And in addition to that, the court may also order any court costs.
So yeah, and what those are often, the legal terminology here is called a writ of mandamus. So counties don't like it, cities don't like it when a writ is issued. And for a city, the cities actually work under 120-day rule. So cities have even fewer days to work through a process. The one thing I will add to Stephanie's description there is at the end of that 30 days, if you deem an application incomplete, then the process is suspended. So you've gotten to, maybe not through the whole 30 days, but by the 30th day, you've deemed the application incomplete. Maybe you've reached out to the applicant and said, hey, you still haven't submitted your traffic impact analysis. We can't move forward without it. Yeah, I'm getting it to you. But on day 30, you send a letter and you say, we've deemed your application incomplete. And when that happens, the timeline, it gets suspended. Under the law, they have 180 days to submit the missing information. If at the end of that 180 days, they haven't submitted it, or at some point within that 180 days, they say, we're not going to submit it, then you move forward with the process. But because you don't have, again, a traffic impact analysis, if that's the missing piece, you can deny that application because they can't meet the standard that you asked for that missing information to show they can meet. So it's usually in the applicant's best interest to make their application complete by submitting the missing information. There's 3 things in the chat, is that,
They were there. One of them,
okay,
yeah. One of them is the link to our comprehensive plan.
okay, I just wanted to make sure we weren't missing anything. Perfect, okay, thanks. My problem for coming in late. I think we're to the quiz now. We've got a test for y'all.
Okay, so number 1, true or false? Planning staff have the burden of proving that all elements necessary to grant the proposed application are met.
False.
Anybody else want to chime in?
You're asking us questions at 7:30.
Okay. So I didn't make this fancy. I didn't do any fancy polls or anything, or make it to where it circled the right answer or anything. Gibbs correct, it is false. The applicant has the burden of proof that all elements are there for granting the application. Okay, so number 2, so planning commission is which of the following? A, the quasi judicial decision maker. B, experts on plan and code. C, a board of really awesome people. D, a resource on legal issues. Or E, both A and C.
E,
I agree, E.
That's correct.
phew, thank God.
Okay, number 3, correctly identified in this slide. The planning commission is holding an initial hearing on a conditional use permit on the 145th day of the 150-day clock. An opponent of the project requests a minimum 7-day continuance. What should the commission do? Should they ask the applicant if they are willing to grant a waiver of the 150-day timeline and only grant the continuance if the applicant says yes? Or B, should they grant the continuance regardless of the applicant's desires? Or C, chastise staff for scheduling the hearing when they did?
I think it's A.
That's what I think too.
Anybody else?
Agreed.
Actually, in this one, it's B.
Oh,
So
dang.
we should,
Hmm.
best practice would be to ask the applicant if they would be willing to waive the 150 days, but they could say no. And because the ask for the continuance has happened, we must continue regardless of whether or not the applicant will grant the
Right. If they ask for continuance, you don't have any choice, right? Is that right? Yes.
Right.
Okay, I got it. I remember now.
Right. Yeah, I think it's C, you should chastise the staff. Yes.
Yeah, you can definitely still do C.
We'll do that
Top
too.
line.
Yeah,
As for us, that won't ever happen. That would be ridiculous to bring it to you on the 145th day. That means we've held on to it for way too long.
yes.
Okay, so number 4, a local government must submit to DLCD at least 35 days before the first evidentiary hearing on which of the following? So a conditional use permit application that was received for A, B, proposed comprehensive plan and land use regulation amendment, C, subdivision applications that are received, or D, all of the above. Everybody's scared to answer now.
Yeah, no kidding. I'm gonna say D.
That's what I'm gonna say too.
B as in boy?
No, D is in
He's
dog.
a dog.
D as in dog, okay. Well, that's a great answer, but I don't have to let DLCD know of any conditional use permit application or subdivision applications.
Jeez.
We can let them know out of courtesy during the process, but they require 35 days from us anytime that we're going to amend our comprehensive plan or any regulation documents, so.
Oh, so it's only B.
Only
B.
B, that's where the,
Okay.
35 days is required by them if we're doing any changes to our plans or regulation documents.
And
I
that
think
used to, oh, go ahead.
No, I was just gonna say, I think that was a trick question.
It kind of was.
So, and it used to be 45 days. And with the advent of technology, it's probably been about almost 10 years ago now, they reduced that from 45 days to 35 days because they then allowed us, we used to have to mail it. And now we can submit it electronically. In fact, they've got this nice portal, you just upload it all to them. So it's real handy. So, yeah.
Oftentimes we do, because we have a local representative, Dawn Hurt, a regional representative. We will notify her in some way, shape, or form of any of the other things as well, just so that way she has an idea of what's happening in our area, so. Okay, and then our contact info, which hopefully all of you have it by now. And any questions or comments, or what would you like to see us talk about in the future?
Well, it's all good learning, but I think at this point, we probably don't even have anything scheduled to get together about, right?
No, we don't have an application for March.
Right. So we had a tentative hold for a date.
It was
We did.
actually Tuesday of spring break, and I can just tell you I won't be there.
That was one of my concerns, was whether or not anybody was gonna be taking off for spring break.
I
We
know.
can skip March, that's not a problem, and actually Carla is going to be out for a portion of March as well, so
Yeah,
it's
I think-
probably,
I
I'll
think
be on
that's,
more in May, but yeah. I would suggest, and again, I have a lot of confidence in Michelle, and her work with you all, but you know, if you guys have questions about the comprehensive plan or the development code, I mean, is there something you want to dig into a little more in depth? I mean, we're happy to have this kind of conversation with you again. So, you know, let us know what you guys want to know.
but I think a review of the comprehensive plan, I mean, it's quite a huge document. So perhaps it's taking it in smaller bites. And since that's something that has come up a couple times this evening, perhaps that's something that we want to address a little closer.
Sure.
Excellent.
What I would encourage you all to do, of the two documents that Stephanie sent out to you, I think the primer that really kind of goes with the PowerPoint tonight is the one that was the Oregon Planning Commissioner Handbook. But I think if we're going to dig into the comprehensive plan and kind of walk through that, and I think it'll be good for Stephanie and I both too, to get a better sense of what's in your comprehensive plan. I might encourage, if you haven't already, with bated breath, been reading the Oregon statewide planning goals and guidelines, you know, to put that next to your nightstand. It'll be good to help you go to sleep at night. But you know, read through that, and then we'll make sure you've got,
I'm gonna send out an email with the comp plan. Hopefully we can all receive it. It won't be too big. I'll send out two emails. One that says, hey, I've sent it out after I sent it out. And if you didn't get it, then we can find an alternative way of getting it. But Erin did share it on the link for the website, so.
It's pretty
Right.
easy to find on the website. There's a search tab and just search it.
Mm-hmm.
Yep. So yeah, we'll start that process. You know, one of the things that we're tasked with in the kind of the first year of our agreement working with Gillum County is to kind of review the various planning documents, make recommendations for where changes or updates might be needed. So you know, having a conversation with you guys about the comprehensive plan is a good way to get some of that done too. So yeah.
So maybe we sort of have, we take on a little homework and each of us on the commission read the Oregon statewide goals and site plans and review the comprehensive plan. And then perhaps we can schedule an April meeting to discuss what we've learned or questions that came up from that.
I think that's a great idea. I can fully get behind that one. Absolutely.
Yeah.
But Marta, I can't hear exactly what this Oregon document is. It's Oregon something. I can't hear clearly what it is.
It's what Stephanie sent it out to us in that first email that she sent out to us. It was attached. It's Oregon.
I have it.
Oregon statewide goals and site plans. Yeah.
Oregon statewide planning goals and guidelines.
Yeah, I have it. Thank you.
So we can read that and then take a gander at the at the comprehensive plan, the Gillum County Comprehensive Plan that we can get off the Gillum County website. And then schedule an April meeting, perhaps towards the end of April.
Yeah, so let's take a look.
Sounds
at that
good.
April date. It looks like it would be the 22nd would be the 4th April, or 4th Tuesday in April.
That works for me.
That works for me.
Works for me.
At 6:30.
Does six work for you guys, or 6:30?
6 o'clock.
6
6
o'clock.
is better. Well, 6 is better for me, but I'm
Same.
retired, so it don't matter.
Same.
Okay. I like 6 because then we're all not completely tired by the time we're done.
Right.
What I will tell you is when you read the not the comprehensive plan, but the guidelines document that Stephanie sent, there are 19 statewide planning goals, and as you had the conversation, one of the slides tonight listed all of those. Only the first 14 are applicable in Gillum County. So when you read that document, when you get to goal 15, you can quit reading.
Right on. I like to hear that.
Okay.
Okay, so our next meeting is going to be April 22nd at 6 o'clock. Are we thinking in person, or are we thinking Zoom again?
I don't mind the Zoom at all, honestly.
What?
I said, I personally don't mind the Zoom at all.
Here's what I would say. Why don't we leave it Zoom unless we have an applicant?
Yeah,
That's
a good
what I was
idea.
kind of thinking.
There we go.
Yeah.
Yeah, if it's just this again, I
Yeah.
think this is fine to stop sharing the red button.
Oh, there it is.
I think if we have an applicant, we need to be in person
I agree with that.
to the best of our ability. But if it's just this again and we're just having this conversation and it's just us here and you guys all at your home, I think this works just fine.
Very good.
I don't disagree. I think that's a great way to go. Lori and Gib, do you agree as well?
Yeah, I think that's great.
Okay, Lori?
Awesome. That's what
Lori-
we'll plan on.
I'm muted, but yes.
Okay.
And at
Okay,
this point,
good.
it's hard telling. Things are rolling in, questions are rolling in, so we may have an application coming soon, but we'll see what happens.
Okay, so thank you,
Thank you.
both you, Stephanie and Carla, for your time. We appreciate you making the effort on our behalf.
Yeah, thanks, guys.
Welcome, Lori and Aaron and Gib. Good to see you. And we will talk again. We'll hear from you in email, Stephanie, and our next meeting will be April 22nd at 6 o'clock as a Zoom meeting.
Perfect.
Okay.
Meeting is
Thanks, guys.
adjourned at
Thank you.
7:44.
Thank you. Good night.